Hi, this is Joe Nohavicka here from Pardalis and Nohavicka, and welcome to Cup of Joe. We have an interesting installment this week. Usually we talk about cases involving the behavior of people, relationships gone bad, people committing crimes. This week's a little bit different because we're going to talk about lawyers and their behavior and when it goes bad. And that does happen. I mean, usually you would think that the lawyers are involved in the case so that they can help resolve it. That's not always what happens. And, is it the lawyer's fault? It is always the lawyer's fault. But there are clients that expect their lawyers to behave like bulldogs. They want, in their minds, they see the lawyer as when they're being aggressive as something that's good for them, and nothing could be further from the truth. What happens is that when you have aggressive lawyers that are causing problems with the lawyers for the other side, is that they're prolonging the cases, and it's just making it more expensive for the clients. It might feel good for a little while watching your attorney arguing with the attorney for the other side. But eventually that means that there's not going to be an agreement and that your case is going to continue on. And that doesn't matter whether it's a civil suit, meaning something like a breach of contract, or if it's a divorce, or even in a criminal case. The lawyers should really try to get along. And I know this sounds sniffy coming, from an attorney who has been involved in arguments with lawyers. Sometimes it's just unavoidable. But the goal should always be to behave as civilly as possible. And we're going to talk this week about behavior that went really, really beyond the pale of what is acceptable for anyone. And unfortunately, I'm going to have to read from the transcripts. I want you to see what happens at a deposition. And let me explain to you what a deposition is. In the civil side, meaning cases that are not criminal cases, you start the case by serving a summons and complaint on the party that's being sued. And then their lawyer, the party that's being sued, their lawyer then serves an answer to the complaint. And that little section there is called the pleadings phase of the litigation. Then the next phase is called discovery. And that's the part of the lawsuit where everyone gets to find out about what the case is really all about and what proof that they have. And some of the ways to do that is making written requests for information. For example, in a car accident case, you would request the other side to give you a copy of the accident report. That's just one example. But the best tool that a lawyer has on both sides is the deposition. And really, a deposition, very simply, is an opportunity where the lawyer, or your lawyer, will be able to ask the party that's suing you what their claim, what their case is all about. And they have their attorney present, and there's a court reporter that's taking everything down that's being said. And after the typing is finished, after the court reporter takes everything down, that gets put into a transcript, and you get to review that transcript. And it gives you a lot of really valuable information, not just about the case, but about the person themselves. Now, this is not usually done in the courtroom. This is mostly done in lawyers' offices, and there's no judge involved directly. You have a judge that's a phone call away, but really it's up to the lawyers themselves to conduct the deposition civilly. And there are rules that guide all the attorneys, but the most important rule is to be civil to one another. And that really just comes down to just being civil during the whole course of the deposition itself, and to not try to impress your client by being aggressive and by not trying to disrupt the questioning of the attorney who's asking the questions at that time. Because you can ask questions and the lawyer who's defending the deposition is allowed to object, only under certain conditions. But all the questions must be answered there are just very few exceptions to that, where a client or a witness cannot or should not answer a question. And I'm not really going to get too much into the technicalities of that. But I'm going to talk to you about a couple of cases now where the attorneys really went over the line. And here's one case out of Texas. And I'm just going, if you just bear with me, I'm just going to read to you what the transcript says. And this is just right in the middle of the deposition itself. So we have this attorney, his name is Joseph Jamal, and he's an attorney from Texas. And this is the comment that he makes. He says, he's not going to answer that. I'm going to shut it down if you don't go to your next question. Then his opposing attorney says, no, Joe, and Mr. Jamal says, don't Joe me, asshole. That's right, an attorney saying that on the record. I mean, this was taken down in the transcript and is still here now for all of us to see. So he says, don't Joe me, asshole. You can ask some questions, but get off that. I'm tired of you. You could gag a maggot off a meat wagon. Now, we've helped you every way we can. And the opposing attorney says, hey, let's just take it easy. But Jamal says, no, we're not going to take it easy. Get done with this. And the attorney says, are you finished? And then Jamal says, I may be, and you may be. Now, you want to sit here and talk to me, fine. This deposition is going to be over with. You don't know what you're doing. Obviously, someone wrote out a long outline of stuff for you to ask. You have no concept of what you're doing. Now, I've tolerated you for 3 hours. If you've got another question, get on with it. This is going to stop. 1 hour from now, period. Go. Now, no information at all was obtained during that exchange when it should have been used to get information that would be useful for the case. It wasn't allowed. But the most important thing, and the thing that troubled the court when it finally got there, was how the attorney treated the other attorney, the disrespect in the language. And that's really not acceptable. I mean, there's an old case that we talk about all the time. It's called Chambers versus Baltimore in Ohio. And there's a statement that the Supreme Court makes, and they say that the right to sue is the alternative to force. Now, you would think that with that as the basis, you know, if the purpose of suing is to prevent violence, it's ironic to have the lawyers battling each other like this. Because this case came very close to fisticuffs, which would be completely incredible and would probably end up with someone going to jail. And I'm talking about the lawyers themselves. Here's another transcript which is even more problematic, and I'll tell you why after. It was a female attorney. Her name was Michelle Rice, and it was her first deposition. Now, I want to tell you something about first depositions. It's a very stressful time for attorneys to do their first deposition. They may not have seen one before. They may not have been trained properly. And they go in and they try to wing it, which is a real mistake. I mean, our attorneys here at our firm go through extensive training. They get to witness and sit in on a deposition, and then they do a deposition under supervision of an attorney. But they do have training. But even with that, your first time, and if you go up against an attorney who senses that this is your first time, it ends up sometimes that you're dealing with a bully who's going to try to get away with things, and you know, and then you know you end up with a bad situation. You end up with a bad deposition, and you end up with an attorney, the new attorney, who doesn't want to do this anymore, and that's really sad because this is really a great thing, and a deposition can be a really interesting part of the lawsuit where you get to actually know somebody else, and you get to work with another attorney. When you have two attorneys who are professional and they know exactly what they're doing, there's no arguments at all. They know better. They know that they can end up by getting sanctioned by the court, because the courts do not approve of misbehavior during the depositions. So here we have Thomas DeCia, who's the opposing counsel for Michelle Rice. Remember, she's the one with the first deposition. And here we go. Let me read you the transcript, okay? So Mr. DeCia starts. What I want to do is get you mad enough so I can try this case. So the witness, his client, says she won't be at trial. I assure you that was meant as an insult to Michelle. And then Mr. DeSaya says, with this bravado, he says, promise you'll let me try the case. And then Michelle says, you should look me up, man. And he says, I did. And then Michelle says, obviously not well enough. And then DeSaya says, I didn't look into whether you're married or not. We're interested as to why you don't wear your wedding ring. And then Michelle says, is that right? You can be interested all you want. I mean, just right there. Can you imagine being asked that and attorneys, trying to be insulting in that way and trying to be distracting? I mean, it's just really, really the acme of disrespect there. So then Mr. DeSaya says, I'm very interested. This is not a white-collar interview that you're sitting here interviewing something with your cute little thing going on. Can you imagine this? I mean, if one of my attorneys came back and said that they were treated this way, I would be really, really upset and very disappointed that another attorney would behave that way. And they'd probably get a phone call with a strong letter to follow, but that's where it would end. So then Michelle says, my cute little thing. And Mr. DeSaya says, this is a deposition that has rules about what kinds of questions you can ask and how to ask them. That's true. You've led him the entire morning. You led him all day Monday when there's no reason to lead him. If you want to lead him to get into a subject area, I can understand that, and I'll let that go. But when you get to the subject area, ask him non-leading questions. Let me just explain to you what is going on here. First of all, Mr. DeSaya should know better, since he obviously does have some experience, that he shouldn't be making statements during a deposition. Michelle was asking questions to find out information for her client, and here Mr. DeSaya is trying to educate Michelle on how to ask a question. Now, a leading question, in case you don't know, and I know a lot of you are attorneys or paralegals, or you enjoy watching and reading law stories. But a leading question would be like, when you went through the intersection, the light was red, wasn't it? All right, see, that's a leading question, as opposed to an open-ended question is, what color was the light at the intersection that you went through? All right, so open-ended and leading questions. Now, the thing is that you're allowed to ask leading questions at a deposition, and the opposing side is allowed to object to it, but you're still allowed to ask them. There's nothing wrong with that at all. Anyway, let's continue on with how Michelle responds. She says, Mr. DeSaya, you conduct the type of deposition you wish to conduct, and I conduct the type of deposition I wish to conduct. This is DeSaya now. He says, I respect that. I'm just saying, respect my defense of the litigation. That's all. Nothing personal, dear. Seriously? In 2020, you're calling a female attorney dear? That's really, really condescending, and none of the attorneys in this firm would ever accept that kind of behavior. So then she said, nothing personal, dear. Let's see. I can't tell you the number of things that you have said that were more personal and certainly offensive and probably, and then she gets cut off by Mr. DeSaya. You told me you're not offended. And she says, listen. And then the witness jumps in and says, now she's offended. All right, so Michelle, at this point, has lost control of the deposition, and that's really, really a sad situation. It's not Michelle's fault. It's the other attorney's fault. There's no doubt about it, okay? Because Michelle is really trying to keep her wits about her and trying to keep everything calm and not let this thing get out of hand so that she can continue to ask questions so she can get information for her client, as she's required to do. It's her moral imperative to do that. So then Michelle says, I'd like to complete a sentence. And then Mr. DeSaya says, your skin is getting thin now. Can you imagine this? Your skin is getting thin now. Michelle says, there are rules of conduct, as you well know, that you have to observe. Whether or not you like being opposite a table from a woman, you have to observe them. And she says, it doesn't matter. Mr. DeSaya jumps in, cuts her off, and says, it does, hun. Hun? Are you kidding me? Are you really kidding me? Why would you say that? Why would you do that? Unless it was your intention to offend this attorney. This is your sister. What is wrong with you? So then Mr. DeSaya says, this is the first deposition you ever took. And Michelle says, right. And then Mr. DeSaya says, I mean, come on, you got to be kidding me. You're not trying the case, are you? And then Michelle says, are you done? DeSaya says, you better get somebody else here to try this case. Otherwise, you're going to be the one sorry girl. Michelle says, a sorry girl? And Mr. DeSaya says, yes. So I just want you to know that this case did go to a hearing for sanctions against Mr. DeSaya. And the thing is that DeSaya claimed to the judge that, and I'm quoting this, he said, I was not aware of any rule or law which required civility between counsel. I mean, that alone, that statement alone shows you that maybe he's just not an evil person, but he really just didn't understand that attorneys are not allowed to be discriminatory, they're not allowed to be rude, and that during a deposition, unless there's some really extreme situation, they're really there just to make sure that the deposition rolls along smoothly. And they're really just supposed to sit there and keep their mouths shut. They're allowed to open their mouths when there is an improper question, and they can object. And usually it's just an objection, and then they allow the client, the witness, to answer over the objection, because that's the rule in the deposition. That's one of the rules that separates the deposition from the trial. Because at trial, if there is an objection, everything stops and the judge makes a ruling. And until the judge makes a ruling, nothing is said. If the objection is sustained, the question is not allowed and is not repeated. If the objection is overruled, everything proceeds as if the objection was never made. Now, I know I talked a little bit about the procedure and how a trial runs and how a deposition runs, and the important thing is, the takeaway from this is that you don't want an attorney who, in your mind, is a bulldog, okay? Because the bulldog is probably going to end up getting in trouble themselves, all right? And you don't want that, because that's going to cost you money. Now, I don't know if the attorney who was sanctioned in this particular case charged his client for the time that he had to go to court and appear to defend the sanctions hearing. I don't know the answer to that, but I wouldn't be surprised either way if they did or did not charge the client for that time. And that's not fair. It's a waste of time. You prolong the case, and that's not what our moral imperative is as attorneys. By being civil to one another, by obeying the rules and the laws that apply to us with respect to our conduct, it's much better off for the client. And you know what? It just makes the profession a lot more fun to be in. I hope this was enjoyable. I hope you learned a little something. If you have any questions, please give us a shout out. Phone calls are always free. Always happy to answer any questions. And come to visit us at www.pnlawyers.com and look up on the blog for more Cup of Joe. And I'll see you next time. Thank you.